Good morning, everyone. Are we waiting for Ms. Ramos, Mr. LaRosse?
I do expect her to be here, but since we're just working on exhibits, I believe, I don't think I need her present for that aspect.
Okay, very good. All right. So we're on 21-7-005319. Mr. LaRosse has just made his appearance for the morning. Good morning, Mr. LaRosse. Ms. Cowan, good morning.
Good morning, Your Honor. Jenny Cowan representing the CASA, Brianna Johnston-Hanks.
Oh, there's Ms. Ramos. Okay. And good morning, Ms. Johnston-Hanks. Good morning, Ms. Zayas. How are you?
Good.
Good morning. All right. And Ms. Ramos has just joined us. Okay. So I think we left off, let me get into share file, with the last one we dealt with was 286. And Ms. Zayas, did you add any additional exhibits over the weekend?
Only I think 3 or 4, not that many.
Okay. All right. And are those, oh, I see, on the 30th. So we've got 5 new exhibits. And I'll hopefully, while we're working through the ones that are already numbered, I'll ask Mr. Mason if he can number those 5. And are you going to offer all of those, Ms. Zayas?
I think so. I forgot to, if you accepted the one that, the restraining order one, or if you didn't accept it, if you wanted me to submit the whole one or not.
Okay, let's see. Do you remember what number that was?
No, I forgot. But I can't remember if it was declined or if it was accepted. I just can't remember that part.
Over the break, why don't you check and see if you can figure out what number it is, and then I can tell you. All right, so let's go to 287.
And I'm offering this as proof that that I've been harassed for a long time, and for 3.1 says for child abuse or neglect, but for not being a parent. So that's why they have been harassing me since 2009, for not being a parent, not for abusing or neglecting my children, or else that would have been marked. It was marked as me not being there.
Okay. So, Mr. LaRosse, your position on 287.
I'd object on the basis of relevance.
All right. Ms. Cowan?
It's, if I'm looking at the right one, it's 287, which is a court, but I think is an unsigned court order, so I object on relevance as well.
All right, because it's not signed by the judge. Let's see. And this was well, I don't know. Is it possible there's an electronic signature for this? I don't know when we started doing electronic signatures.
This is from 2014. And so there would not be electronic signatures by judges. That started with the COVID situation. And Ms. Cowan is correct. Not only is it not signed, but it
is signed by you guys.
Pardon me?
Signed by a social worker.
Pardon me. It is not an order that was entered by the court, because not only was it not signed, but in the front top page, it doesn't have a new hearing date, and the review hearings indicate what's going to be happening next. And it doesn't indicate who is present. So this appears to be a draft. If Ms. Zayas is requesting to admit it to show that at that time the department was still maintaining that dependency was based on C, 1334 or 30 sub 6C, I would stipulate to that.
I think that's
she's not going to accept anything of mine.
Ms. Zayas, I think is that the purpose for you offering 287 is to show that the department in 2014, so let's June of 2014, was proceeding against you under subsection C. Is that correct?
Yeah, that means I did not abuse or neglect my children. None of them all of their court orders say the same thing. So they're never, ever, ever saying that I abused or neglected my children in history.
Okay.
So that's kind of important because, you know, we're here still because I'm not a parent. We're not here because I abused or neglected my child. And that's kind of important because the Constitution requires that they only pick up my child if I abuse or neglect my child. I just sued DCYF for this yesterday. So it's a little bit important.
Okay, so this is being offered as a statement of a party opponent, the department's statement that they're seeking action against Ms. Zayas based on subsection C. It appears for that purpose, Mr. LaRosse doesn't have an objection to that. Is that correct, Mr. LaRosse?
Correct.
Ms. Cowan, do you have an objection to that limited purpose?
No.
All right.
No, Your Honor.
So the court will admit 287 as a statement of a party opponent that they're proceeding against that the department was proceeding against Ms. Zayas under subsection C. All right, 287 is admitted. All right, 288.
My computer's slow. Okay, this is off of their website, off of childwelfare.gov, regarding case planning and laws and stuff that go with it. And so basically on page, and I got the whole thing on there, so it's not part of a page or whatever, but on page 2 is, it says that the parent doesn't have to participate, basically, if they refuse to participate. That's what it says to me, but I'm not sure what you guys get from that, but this is child welfare law, and I think that they're child welfare. I'm pretty sure they're not just RCW by themselves, don't have to follow child welfare. I think they do have to follow the law according to their Children's Bureau or whatever the heck it's called, because that's who is in charge of the Children's Administration. That's who's in charge of CPS. So they kind of have to follow their policies. They can't just go on their own and try to make up their own. And also on page, the very bottom where you find Washington State, you will not find option C. There's no such option C. So, I mean, they don't, it's all the same except for option C doesn't exist anywhere in child welfare.
So the Washington portion is on page 63 of the document. I'll give the parties a minute to look at it.
And it also stipulates that a parent has to be a part of the case planning. They can't just go on their own and just, make up their own case plan.
So I believe Ms. Zayas is offering pages 1, 2, and 63. Is that correct, Ms. Zayas?
Yes.
Pardon me. No objection.
Okay. Ms. Cowan?
No objection.
Okay. Court will admit Exhibit 288, and the court will consider pages 1, 2, and 63. 289.
The court will grant the motion for a finding of dependency by default as to that parent, and then enter an order of dependency as to that parent. So the order that is contained here, or the two orders that are contained here, are an order for default as to the unknown father and anyone else claiming a parental interest, and then an actual FFCL, finding of fact, conclusion of law, setting forth the basis for a finding of dependency as to that individual here, the unknown father and or anyone else claiming a parental interest. There are, pardon me, there need to be orders of dependency entered as to every person who has a legal interest.
Yep, it's doing it again. Can you hear me, Mr. LaRosse? I can't hear you. I can't hear you. Hang on one second. Okay, can you hear me now? All right. So we're having courtroom audio problems. So hang on with us. Okay, that should have fixed it. Did that fix it? Okay, hang on one second. Let me turn up my volume so that we can get a good recording. Okay, this is the same problem that I kept having last week, and they came in and worked on it and obviously didn't fix it. So we're okay, Mr. Mason, are we making a good record? Okay, Mr. LaRosse, would you just speak a little bit?
A, B, C, D, E.
Great. Okay, thank you. Okay, continue, please.
All right, so I'm not sure exactly where the court lost me, but basically there has to be an order of dependency as to every individual having a legal interest in the child. In this case, there was an order of dependency as to Ms. Zayas that was entered following a trial. As to the unknown father, anyone else claiming a parental interest in the child, that was entered by default following service by publication, and that default order and finding of dependency is the order that is the subject of, what is this, Exhibit 289.
Okay. So Ms. Zayas, with that explanation that this is the default order as to the unknown father, do you still wish to offer 289?
Without me knowing is because it's a crime and they're not allowed to do this. You can't, it has to be a person, it can't be an unknown, we don't know who it is. I mean, a person has to be, you have to name a person. So we don't, serve court orders to unknown. There's no such a person as unknown. Okay. So, yeah.
All right, so Ms. Zayas is still offering 289. Mr. LaRosse, your position on the admission of 289.
Oh, that's fine, no objection.
Ms. Cowan.
I agree with what Mr. LaRosse said, and it's also supported by 1334-080 on the unknown father. So no objection.
Okay.
So is she saying it says in RCW that we can serve unknown people?
Hold on. 289 is admitted, and then because it's been admitted, Ms. Zayas, you can use it in your closing argument, or you can testify about it when you get to your testimony and make your explanation to the court about the importance of it. Okay, so let's move on to 290.
Oh, this is for my I think this might be a repeat too. No, it's not. This is okay. So this is a proof of racism. This is what they do. They make these little court documents and they try to make me go crazy, and it's signed and everything, but they just say dumb stuff in it, like oh, poor Marcel, he's in trouble, oh my God. And so they try to make me react, and I did react to this. So this is all their entire goal in life. This is their job description. Make the biological parent go nuts, and here's how. So they make these little stupid court orders that make no sense, and they talk about my child being hurt by this guy that they placed him with. And then they're taking him away and blah, blah, blah. And yeah, this is just proof that they're racist, pretty much. In any direction, too, not just black and white, but they're just racist.
Okay. Mr. LaRosse, your position on 290?
I don't object to 290. Well, I mean, I object on the basis of relevance. Sorry to change my mind there, but I do object to Ms. Zayas's statements being admitted or accepted as evidence vis-a-vis the abuse of the child that occurred as hearsay.
Okay. All right, so let's take these, Ms. Cowan, and then we'll take these things in turn. There's two issues. There's the testimony and then there's the document. So start with the document. What's your position on 290?
It's hearsay and relevance.
Okay. And what's your position on Ms. Zayas' testimony?
I agree with Mr. LaRosse's objection.
Ms. Zayas, there's been a hearsay objection to...
It's a court document. It can't be hearsay. It was filed to the court.
To your testimony that Mr. molested...
That's in another court document, too. I just submitted.
Okay. So based upon the fact that that evidence is in another court document that's been admitted, Mr. LaRosse, as to the testimony.
He submitted 85 pages of his hearsay. And I said it was hearsay every time, and you still let him do it. But I said hearsay every single time, and you're like, nope, okay, nope. Yeah, we're just going to let it go on through. We just love the AAG, but we fucking hate parents. I could see that happen. What, Mama?
So in regards to, if something has been stated in a document that has been admitted, then it's been admitted. then that information has been admitted, but the specific statement by Ms. Zayas still is hearsay, and so the the court should restrict its consideration to the information that has been admitted. The department still objects to the statement of Ms. Zayas as hearsay.
Okay. And Ms. Cowan, do you concur?
Yes.
Okay. So the court will refuse 290.
Why didn't you refuse anything I said that he said was, I said every single one of his emails were hearsay, and you said, nope, we're submitting it. Nope, we're submitting it. You didn't care what I said when I said it was hearsay.
The court will refuse 290. It is a few things. It is hearsay, but it's also cumulative. Ms. Zayas has admitted prior evidence.
No, it's also retarded that you always accept his. When he says hearsay, you throw it out. When I say hearsay, it's nothing to you. You're like, oh, well, and you know it's hearsay because it's an email. And you still say it's okay to admit. All emails are hearsay, but you admitted all his hearsay. All of it.
The statement of the department within here is not hearsay, but the statements that
The emails are all hearsay.
the statements that the department
You don't know who sent that email.
the statements that the department is recounting is hearsay.
So, but you discounted my entire document when I discounted one part of when he discounted one part of it. But when I discount his entire document, you're just like, what? Who cares?
And there is Ms. Zayas has admitted and has testified about, and it's been admitted that the department placed, and so that.
What's the point of going through all this if you're just going to discount all my evidence?
Leave
me with all this bullshit evidence that he's got, that's all hearsay, and you're going to believe that, and you're going to take that and try to terminate my rights, but you're going to take all my evidence out like it's not proof that they're actually black. It's not proof of that, and they're racist. That it's not proof of that. I proved that, but you're going to take all that out. That they're black. You're going to take it all out. You won't put the black people stuff in, huh? Is that what it is? Are you scared of black people too?
So 290 is
that what it is?
Refused, and we can move on to the
No, I think I'm just going to sue all these people up here in these boxes, all these names right here. I'm just going to sue them all, and then they'll all lose their jobs. How about that?
So Ms. Zayas has disconnected. I am going to ask our bailiff to email her, of course, copying all of you, and invite her to return so she can finish offering her exhibits. And Ms. Ramos, if you wish, you are welcome to reach out to her and see if she would like to rejoin. We will take a recess until 9:45, and I'll see everyone back at 9:45. All right, so we'll move on to Exhibit 291. Whenever you're ready, Ms.
This is the sentencing of Bianca Bradley. I think I already did this one, didn't I? Or did you reject this one already? Because it's from...
No, you talked about this one, but we hadn't gotten to look at it yet.
Well, this is what the department gave my son to this man. You know, he's got three murders on his record, actually. And he just got out of prison for murder. And they favored him, and he's never peed clean in his life. He's never done a single service in his life. He was always allowed to reject services, and he spent the entire time, as you can see, you see the time he was sentenced. It was the exact time that we had the entire dependency. He spent the entire 5 years in prison, but they gave him custody of my son.
Mr. LaRosse, your response to the offer of 291.
As to the exhibit objection based on relevance, I also have a separate objection, hearsay objection to the testimony offered by Ms. Zayas.
Okay, Ms. Cowan.
I join in those objections.
Okay. The court will admit 291. It is relevant to Ms. Zayas' theory of the case. The court will refuse the testimony given Ms. Zayas about Mr. Bradley never peeing clean or doing services. I believe there's other exhibits that address those issues that have been admitted that are not hearsay. So 291 is admitted.
But you don't see any clean drug screens from him, though, so that's the point. Yeah. They could talk, but that's all they do is talk. They don't have any proof.
All right. 292.
My computer's slow.
That's fine, Ms. Zayas. I understand.
Oh, this is just proof that Amaya was clean, well-groomed, fed, and happy, according to the doctor. According to the reporter who reported her supposed child abuse, if you look underneath at the very bottom, it says, the referrer stated that Amaya looked clean, well-groomed, fed, and happy. So, I mean, as much as they reported that I left the hospital because I had high blood pressure and I didn't have a babysitter, but they still said she was fed, well-groomed, clean, and happy. So that's, I mean, I guess child abuse, that's what child abuse is.
Okay, Mr. LaRosse?
No objection.
Okay. Ms. Cowan?
No objection.
292 will be admitted. We don't have a 293. So we'll go on to 294. Mr. Mason just skipped in the numbering, Ms. Zayas, so you're not missing anything.
This is Emergency Order 6. The order that they were supposed to be following, it was effective on the 10th of March. And they all get the orders before any, as a matter of fact, they don't mail these orders to anybody's house. They should, but they don't. They just give it to the police departments, the CPS, all the law enforcement agencies. They already have it. They know that these orders exist, but the parents don't know.
And which page of this are you asking?
The entire thing.
The entire thing. Okay.
Yes. It's all relevant. It's all to do with dependency courts. They should not have had court that day. They should not have even taken her because it was for mission critical reasons only. And dirty P is not mission critical. I mean, it didn't say that in the list of reasons anyway.
Oh, I see. So under page 4, mission critical hearings. Okay. All right, Mr. LaRosse, Exhibit 294.
No objection.
Ms. Cowan.
No objection.
Okay. 294 will be admitted. All right, 295.
This is a page out of the discovery, but it's not the whole thing, so I guess it'll get thrown out, but just more proof of child abuse.
So, this is about Jasmine?
Yes, after she was forced to live with him, yeah.
All right, Mr. LaRosse.
I'm going to object based on hearsay and relevance and foundation. This is an undated case note.
Ms. Cowan?
Hearsay and foundation.
The court will refuse 295 while it is I will overrule the objection to foundation. But I will sustain the objection to hearsay. It is a department document, but the department is recounting hearsay by others. And so 295 is refused.
Can I submit the entire discovery then?
So I overruled that part of the objection, that it was...
So nothing written by a black person is going to be submitted then?
The reason that this is, it's not that if the writer's words are not hearsay, but the writer is saying that Jasmine said, and whatever Jasmine told the writer is hearsay. Jasmine could testify if you wish.
But the emails are all hearsay.
If you wish to call Jasmine to testify about things that...
No, but the emails are all hearsay. You don't know if that was me writing that email. You weren't there. You weren't. So you don't know if that was me writing that email.
So 295 is refused. 296.
This is why I don't stay in court, because you're corrupt.
296.
I think 296 is part of 87.
Yeah, Ms. Zayas, is 296 the same thing as 287?
Does it matter? I don't run shit anyway.
Oh, wait, my mistake. 287.
No.
Let's see. 289?
I'm on 297.
Oh, you're on 297? Okay. So you're not offering 296?
This whole thing better get admitted. It's all forgery and bad.
All right. Are we talking about 296 or 297, Ms. Zayas?
297.
Okay, we'll go to 297.
I'm sorry, can we clarify what happened with 296? Is it being offered or?
Ms. Zayas is not offering 296, correct?
I can't see it. It won't show on my screen. Hold on. It's the same thing as I just offered before.
Yeah. So she's not offering 296. It's a duplicate. So.
Okay.
So now we're to 297. Is 297, oh no, 297 is not a, okay, 297 is a shelter care hearing on...
Just a forgery, yeah. Now, Ann Daniele did not work for King County when this happened. She was voted out in 2008. Now she works for them again, but I don't know how that happened, but she did not work for them when this happened. And on the top page, it also says that they knew that I wasn't going to have court for months, so they didn't tell me this. They didn't even give me this document. They wouldn't give it to me at all. And they told me I didn't have to do any services at all at this court date. Yeah, they are corrupt. I had to delete Amaya's name because I used this for the district court, so I had to redact her name out of it.
All right, any objection to 297, Mr. LaRosse?
No objection to 297. I do object to the hearsay testimony and lack of foundation as that testimony by Ms. Zayas.
And which in particular?
They told me I didn't have to do services.
It was the pandemic. They told everybody that. Pandemic, you know, and they're shutting the courts down. So when nobody could do services, everything was closed.
Ms. Zayas, who is they?
The courts were closing. They were closing the courts. The police, everything were closing.
Okay.
So there's no way anybody could have done anything. So the lawyers were closed. We couldn't even get a lawyer.
So are you saying that, do you have a recollection of a particular person telling you you didn't have
United States
services?
government. You don't remember going into lockdown? You don't remember the pandemic?
Okay.
When they closed everything? Nobody remembers that.
All right.
Yeah.
But did a particular person tell you that you didn't have to do services because...
Jay Inslee? The governor? Your boss?
Okay.
That guy.
All right. With that clarification, Mr. LaRosse?
Yes, I object to that testimony.
Okay. Ms. Cowan?
Your Honor, is this, as to the exhibit, I think Exhibit 5 is the same thing, which is admitted, and then as to the testimony, I join in Mr. LaRosse's objection.
So there was no pandemic, you're saying?
Hang on, Ms. Zayas. Let me look at 5 and then I'll address the testimony. So 297 is slightly different. It has a blue ink signature by the commissioner, and it does not have the stamp. Ms. Zayas, is there a particular reason that you want your 297 admitted in addition to Exhibit 5? Yours has blue ink signatures by everyone and no file stamp.
Well, there's a file stamp on theirs?
There's a file stamp on their Exhibit 5, yeah.
Oh, yeah, there's no file stamp on the one on the docket. There's not one. Oh, wait, that's right. They took it off the docket. Yeah, this document was taken off the docket because it's forgery. That's right. Oh, I should get a copy of the... No, I already have that. Yeah, it's not on the docket. I don't know if you guys ever look at the docket, but document 11 and 12 are both not on the docket because they took off the forgery. Yeah, there you go. There's proof that it was forgery because how can you take anything off the docket? They're crooks.
So the court will admit 297. It is slightly different. As to the testimony by Ms. Zayas that they told her she didn't have to do services, she attributes that to the governor's lockdown order. And insofar as she's asking the court to take judicial notice of the governor's lockdown order.
I wouldn't have done services anyway.
No
matter what.
I will take judicial notice of that. I will also later receive testimony from her, if she decides to give it, about how the lockdown order might have impacted her ability to do services, but I will not attribute the statement to anyone other than the governor. All right, 298.
298 I already have somewhere else. You can pass that. I already have a copy of it somewhere else.
Okay, 299.
Sorry, one sec. I have to refresh. I don't have a 299. Let me just check here.
This is the entire discovery. I don't remember how many pages it is. 59 pages. I can't remember why I admitted this. Oh, yeah. Reason why I don't comply. There you go. That's it. I had to put notes to myself because I don't remember why I admitted everything.
And this appears to be the department's case file with respect to Marcel Bradley Zayas.
Sorry, I'm just taking a look at this.
Sure, that's fine.
This has the report that I just admitted the picture of. And this is why, yeah, because even though I was complying,
they kept saying that I wasn't complying. So that's the whole point of me not complying.
So this seems to be a combination of several documents from Pierce County. These were provided by the department. I guess I would object on the basis of relevance. This is from 2009?
To 2015, it goes all the way to 2015. But it just proves that I was in compliance, and they always said that I wasn't, even when I was. So that's why I put it on there. And you said not to put parts of the discovery on there, so I put the whole thing.
All right, Ms. Cowan, your position on 299?
No objection.
So the court will admit 299. It does support Ms. Zayas' theory of the case. All right. Exhibit 300.
I don't have 300.
Oh, refresh your share file, Ms. Zayas.
This is the same stuff. You're probably going to throw it out. It's just the entire discovery. Because you guys told me not to put pages in, so I put the whole thing in. And it says on the very top, it says 81 pages, and there's 81 pages. So there's the entire thing.
So I'm not seeing what child this is about with all this confidence.
I know, but the point is, that's my point. Why am I talking to police for 20 years? That's what I want to know. Like, who has a right? I mean, if a police officer was at somebody's door every day for 20 years, they'd get in trouble for that, wouldn't they? You can't harass a parent for 20 years. Something's wrong. And you're constantly marking that the parent's not there. You're never marking child abuse. You're never marking that in any of the court orders. You don't think something's wrong with that? Like, I mean, that's harassment. Like, every single day that I have a date with these people should be a crime because there's no proof of child abuse or neglect. So why are they talking to me? Why are we still going through this? Why do we go through 20 years and 6 kids, okay? They've harassed me during my pregnancies several times where I've had to give my child up for adoption because I was scared that they were going to take my kid. That should prove harassment. Nobody has to talk to the police for that long. Nobody wants to hang out with a social worker. Nobody wants to hang out with a social worker. Not even real people want to hang out with social workers. People who work in this industry, nobody likes them. Why would I have to be subject to them for 20 years? Just please tell me why, because I don't see any child abuse ever. And I'm trying to prove to you guys that there's no child abuse by showing you all the discovery. I gave you a link to my entire discovery. You have access to the whole thing. You can see that there's no child abuse. So why am I talking to them? Why are they still getting gas? Why are they still getting money from me? Why are they still paying thousands of dollars for psychological evaluations? Why? Or why am I still talking to these black people? I don't get it. I'm lost. That's all. That's proof of harassment and racism, really.
All right. Mr. LaRosse, your position on 300?
I'm looking through it. This seems to relate to an individual that indicates that is a related participant.
And he was unfounded for child abuse after molesting her, by the way.
No objection.
Okay. Ms. Cowan?
No objection.
Exhibit 300 will be admitted.
The next one is the law, and it's the entire one. Since I didn't want to just take a page out of it, hold on.
Come here, baby. What's the matter? What are you doing?
Oh, this is the entire law. Page 12, Part C is what you want to read. That's the part. But I didn't want to put just part of it on there because then you would say, oh, it's not good because it's not the whole thing. So I put the entire thing on there, and page 12, Part C is the important part that you guys should abide by, but you don't.
All right, so Exhibit 301 is, I believe, the 1977 version of RCW 1334. Any objection to 301?
I will object on the basis of relevance. The nature of the statute in 1977 does not pertain to the application of the law as it was, pardon me, in effect at the commencement of the 2020 dependency as to Amaya.
Okay. Ms. Cowan?
I join in that objection.
Okay. The court will admit 301. It is relevant to Ms. Zayas' argument about the constitutionality of subsection C as it currently exists. The court will not apply the 1977 version of subsection C. But Ms. Zayas is making a record and an argument that the currently constituted subsection C is unconstitutional. And so I will admit 301 for her to be able to make that argument. All right, 302.
Just more clean UAs I found. And when I used to do services and they said I never did them, this is why I don't do them now. Because I used to do them all the time like a dummy, and then I just stopped because I realized that they don't care what I do, that they always say I don't do them anyway because they're black, so that's what they do.
So this appears to be a copy of the dependency petition as to Amaya from 2014. 2015.
No, 302 is a printout from working.
Oh, I was looking at the wrong one.
Yeah, it's a fax from Working Choices to Working Choices from, anyway, you can look at it. It has UAs from 2014 and a description of an description of an intensive outpatient program.
Oh, there's no dispute that Mom did services in the first dependency, so I have no objection.
Okay, Ms. Cowan?
No objection.
302 will be admitted. 303.
303 is proof of racism again. I never met this person in my life, and she created this removal order. This is the author of all of Sheila Wilson's little writings, and I tried to look her up, and I found out nothing. But I'm going to sue her this week, actually, so that's a good thing. She still works for CPS, but she wrote this in 2015 and tried to take my daughter when I was in full compliance for, I think going on almost 2 years of full compliance, and she tried to take my daughter for, God, I don't know, she made up a bunch of stuff, and it was just all lies, basically. Why?
So are you offering her assertions for the truth, or are you offering them to say that they're lies?
No, what she did was she took all the stuff that they are basically I was in compliance the whole time, and they wrote that I wasn't. They wrote that my house was dirty. They wrote everything that they wrote was a lie. And so, but all the stuff that you read in that discovery that I submitted also says the same thing. And but I was in compliance because if I wasn't, they would have taken Amaya. So they didn't have Amaya in their care. They never had Amaya in their custody. When she was born, she came home with me. So, but what she's doing here is she's trying to take her, and I didn't even know that this was filed. I had no idea. And my lawyer never told me anything about this. So I had no clue. But it just proves that, to me, it just proves they're racist. But, but that's proof of, it's proof of harassment. And even though I was in compliance, they still try to take her. So it's kind of like, why would I comply now when every time I do comply, they still try to take my kids anyway?
Mr. LaRosse, your position on 303?
I'm sorry, one moment here while I try to... So this appears to be an amended dependency petition that was filed in the 2014 dependency that had already been filed, not as a separate dependency filing or like a different case. No objection.
Okay. Ms. Cowan?
No objection.
303 will be admitted.
The next one is Amaya's health record that was Krause, what's her name? Mariah Krause asked for this health record in 2019. I think it was, I don't remember what month it was, but she asked the doctor for this health record. And it just proves that I did take Amaya to the doctor, so, they can try to say that she was so unhealthy or underweight is what they said. Yeah, that's right.
So you're offering this to show
that I took her to the doctor?
That you took her to the doctor.
Yeah.
Okay. Mr. LaRosse, your response to 304?
I'm sorry, I needed just a moment to review this because I didn't see it previously. No objection.
Okay, Ms. Cowan?
No objection.
Okay, 304 will be admitted. Okay. And finally, 305.
Just more drug screens that I found that, I don't know, I probably already have these. I don't even know. I forgot. I don't know.
One more thing I wanted to say is I meant to add the no-show ones because as proof that they lied because I never had any no-shows, but I didn't add them, but they're also in the discovery. And I didn't know if I could add them because I thought that maybe you guys would put them in there as ones that I didn't show up to. But anyway, she put a bunch of fake no-shows that I didn't show up for. But if I really wouldn't have shown up, they would have just took a Maya. So, I mean, obviously it's not true. But I was going to add them, but I thought you guys would add them and then say that I didn't show up. So I just didn't add them.
I'm just looking through these. No objection.
Ms. Cowan?
No objection to the UAs, but I object to part of Ms. Zayas' testimony around the fake no-shows. I think that's foundation and hearsay.
So the court will admit 305 and will not receive Ms. Zayas' testimony about fake no-shows.
And even if I did know we were going to trial, I don't have any friends because people don't like hanging out with people that lost all their kids to CPS. People don't, they don't say, hey, I want to be that girl's friend because she lost all her kids to the state. Yeah, she's a cool person. People don't like people like me. I wouldn't be friends with someone like me either. I don't have any friends. Sorry.
So, Ms. Zayas, do you wish to call Ms. Ramos or
Hell
Ms.
no, I'm not calling none of those people. They're corrupt and they lie all the time. Everything they said was a lie. So yeah, no, it's not. No way. I'm not going to enjoy their lives anymore. Sorry.
And do you wish to testify and tell the court anything? Do you wish to testify?
What do you want me to say?
I want to hear whatever you want to tell me.
Okay.
But I have to
is this
swear
like,
you.
what is this going to be considered?
So right now, if you testify, it'll be evidence that I consider when determining what to do. And Mr. LaRosse will have a chance to cross-examine you, as will Ms. Cowan, if you decide to testify. All right, so please raise your right hand. Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, and I want to ask you, I'm not going to make you ask yourself questions, but I am going to ask you to keep your testimony organized into topics. So if you could just let me know what topic you're going to give testimony about, and then the next topic that you're going to give testimony about, and so on.
Racism, why I don't do services.
Okay. So start with either one of those and give me testimony about either one of them.
Okay. So a long time ago, on October 1st, 2009, after I refused to let CPS in my house and after I refused to talk to CPS, they came and took my 6 and 8 year old from their school based on a dog bite that my son suffered from. And basically, they favored my child's father the entire dependency. They gave him custody, and they never planned on giving me custody again. And they favored both of the fathers, who were both African American, and they were actually both homeless when one of them called CPS on me and said that I was feeding my kids cereal for dinner, and that I was on drugs and all this other stuff. But basically, they ended up getting custody, and I thought I'd get him back, so I stayed and I signed the dependency order like a dumbass. I will never do that again. But I signed the dependency order every 6 months.
I apologize, but I have to interrupt briefly. Your Honor, I'm going to have a standing objection to hearsay unless Your Honor...
I'm allowed to talk, right?
Yeah, Ms. Zayas, hang on, but they're allowed to object, just like you objected during.
Oh my God, they're going to object the whole time then.
So, Mr. LaRosse, unfortunately, I think I'm going to need you to object each time. So.
All right, I'll raise my hand as necessary. Yes, okay.
All right, thank you. All right, go ahead, Ms. Zayas.
Well, the proof is in the record that I signed the dependency order every time, and when I went to drug treatment, they would not bring my kids to come visit me. That's part of the number one reason why I left drug treatment every time, was because they would not bring my kids to come visit me. So I'd have like a 3-month blackout
and they wanted me to sit for 3 months and not see my kids. So yeah, I left treatment, and they said, "Oh, Miriam left treatment again." And so, but the whole time they did that on purpose. They knew that me not being able to see my kids would make me leave the treatment center. So they would not bring my kids to come see me, so that I would leave the treatment center. They had an option to bring my kids to come see me, but they didn't. They refused to. Just like they did in prison when I went to prison 20 years ago. They would not bring my kids to come see me.
We have an objection. Mr. LaRosse?
Objection to they refused to bring the children to see her in treatment.
Well, they don't have proof that I did, that they did, so that's proof right there that they didn't. Anyway, the treatments, all the treatment centers had a blackout period of 2 weeks or months. And then, even after the blackout, Jamia would not, she refused to bring them because she would say, you know, they're at their summer camp or they're have to visit the dads and we can't do that and blah, blah, blah. So I would end up leaving the treatment center just to be able to see my kids. And they would say, well, she didn't comply, she didn't do whatever. And I did finish treatment. I want to say 3 times I completed inpatient, and then I went to outpatient, and I paid for it out of my own pocket, even though I didn't have a job. And I stayed in outpatient for a while, and there were several times where I completed all my services, and we would go to court, and they would still say I did nothing. And I thought I was in a dream. I thought I was like in a trance. I couldn't believe what I was hearing sometimes, because I would go to court, and I would think that she's going to say the right thing. And it would be like I'd go to court, and the judge was black, my lawyer was black, my social worker was black, the dads were black, and I was white. And everything I said or did, they didn't keep record of anything that I did. They didn't keep record of my treatment. They didn't keep record of anything. And they would just go to court and say I did nothing. Even though I would just be done with treatment, they would always tell the judge I did nothing. And I would give them all my records. I would give them all my, I trusted that they would say the right thing or do the right thing. And they go to court and say, oh, she didn't do anything. I swear to God, I know it sounds crazy, but every 6 months they would go to court and lie through their teeth. And I know you probably, I don't know if you're a family court judge, but I'm telling you, these people, they do it all the time because they're pro-adoption. The Adoption Safe Families Act, plus there's a law called 42 U.S.C. 601 purpose. And it's actually a federal statute that's non-positive, but it's the purpose of why they exist. It's the purpose of welfare, it's the purpose of CPS, and it's the purpose of child support. And it says in that purpose to form and maintain 2-parent families. Form and maintain 2-parent families, they're not talking about our families. They're talking about foster families. So their job is to form, and their goal is to form and maintain 2-parent families. So they're targeting me because I'm single, and they hate that. They want to take all my kids and give them to married families, Christian families, force them into Christianity, and that's the government. That's what the government does. So anyway, so that's what I figured out why they're doing this too. But the way they're doing it is also corrupt. And like I said, I complied the whole 6 years. I tried everything I could to get my kids back, and it didn't matter because every time we go to court, they would lie and say that I did nothing. So for them to be shocked and surprised that I tried to do something this time. I still try to do. I couldn't believe that it was happening again this time. I was like, oh my God, these people really got nerve. It's like I told them too when they first took them. I said, do you know who I am? You should check your records, like who I am. I've got such a long record. It's like, why would you do this? It's like they almost want me to explode like a bomb, and I did. And I would have sued him a long time ago if I knew how to sue, but I didn't know how to sue. And I didn't know I could sue by myself. I thought we had to have a lawyer. And people always used to tell me that, you can't sue until your case is closed. But that's not true. And so when I found that out, I just started suing everybody. And thank God I did. And, I believe that everything happens for a reason. I believe I'm here for a reason. And I believe that the only reason that Anya's with me right now is because they didn't know when I was giving birth. And I believe they would have taken her from me if they would have known I was giving birth. And I think they're corrupt. And I think that proof in everything else that I've already done shows that I did try at one point and they still denied it. And I'm not just like a flailing dope fiend with needles sticking out my arm. I'm not, there was a time when I did comply. There was a time when I did do what they wanted me to do. They never, ever accepted it for me actually doing it. They just denied and denied and denied. And I mean, the fact that they even wrote that I was still prostituting and still, when I was working and I was in college, is like, I mean, I was working in school and they still wrote that I was a prostitute on drugs. They told my daughter the same thing when she was 14, and so she decided to be adopted by them. It's like the things that, it doesn't matter what a parent does. We all know that they're corrupt and they don't accept anything anyone does. And to me, it's child abuse from them because they enjoy knowing that Amaya's hurting. And Amaya's cried almost every day for the entire 2 years. And it's been 2.5 years, but she cried every day for 2 years. And the fact that they know that and they're okay with that and they keep going and going and going just shows that they don't care about children. It's so obvious. It's like, it's almost like they say they do, but I'm sorry, I just don't see it. And the fact that they schedule hearings on me and her's birthday, that's just a sign right there. I mean, why would they schedule hearings every year on our birthday? What's the point of that? You're trying to cause pain to a little kid. That's painful. And it's okay with them to do that. The Robert Ferguson or whatever, it's just, they're corrupt. There's something wrong with the system. And I'm not, the reason why I'm not complying is because I don't have to comply, because they have to have proof of child abuse. It all has to go in order. They didn't go in order in the first place. You can't take someone to jail and say, okay, now you have to go through probation just because you're in jail. It doesn't work like that. You can't do that. You have to have probable cause to arrest them, or they're exonerated, or they're gone, or you have to let them go. You can't just say, oh, because you're here now we have to do this. No, there has to be, everything has to add up. You have to have probable cause. You have to have child abuse and neglect. You cannot take someone's kid and then say, just because she's here, now you have to do services. Sorry, it doesn't work like that. And I don't care if they've been doing it like that for years, and I don't care if they've been getting away with it like that for years. I will publicize every bit of this trial, and I will put them on the front page of the paper, and make sure that the world knows, because it's not that expensive to do. And that's my goal. My goal is to abolish CPS. And by myself, I will abolish CPS. And I don't care if it takes 1,000 times. If I have to sue them 1,000 times, I will sue them 1,000 times, each one of them. And if it's all it takes is lawsuits, then oh well, at least it's public. Somebody's got to know. Somebody's got to. I'm not the only parent sitting here going crazy. They're all white parents, though, for sure. But I'm not the only parent, and everyone underneath everybody else is black. But I'm pretty sure you know that. Everybody's boss. People who trained Brittany, people who trained Julie, black lady, black lady, black lady. Of course, they all hide because they're scared. Her name is Felicia Johnson. She trained all of them. She trained Shay. She trained Julie. She trained Kelsey. She trained all of them. And she's being sued this week too. But I was looking for something I was going to say too. Hold on a second.
Ms. Zayas, we need to take our mid-morning recess, so we'll take 15 minutes and go ahead and jot down your notes about the topics you want to talk about, and then we will resume at 10:43, and we'll resume your testimony. Okay, we'll be at recess. Thank you.
Also, I want to say, they, first of all, excuse me, you're going to hear her scream because she doesn't have her bottle yet, but hold on. Violated emergency order 6, took her lacking probable cause. They forged a removal order, forged a shelter care hearing order, refused to give me any visits ever. And I mean, I don't ever get visits, like ever. It's not just once every couple weeks. It's all the time I never get visits. And the visit monitor is always late to every single visit. There hasn't been a single visit in this since 2020, where she's been on time. She's never been on time. They've always been at least 15 to 20 minutes late every single visit. Let's see. And then they committed perjury at
dependency trial and accepted the perjured testimony from Ms. Boyette. Obviously, I proved it was perjury, but afterwards it doesn't matter. I still proved it was perjury. And you know, just to even base the dependency on someone missing school and not being dressed for school or whatever is that. I'm sorry, that's not dependent. Like, you could fix that by just giving them some food or whatever. It's not child abuse and neglect. That's a child lacking basic needs. And that's not child abuse and neglect. That's a hungry child. I don't know. They could have fixed that. And so it wasn't, that's not a reason to put someone in a dependency. Because, I mean, there's nothing that I could do as far as classes go to make me have more food. You know, there's nothing that I could do as far as classes go to make me buy better clothes for my daughter. You know, you could just give me that, but not take my kid. That's stupid. And they didn't even know that much until the dependency trial, which was, I'm sorry, Amaya's singing a lot right now. But they didn't say that until 8 months after she was taken. So that was, none of that school stuff came up until 8 months after she was taken. So that, all right, let me read the rest of this I wrote down. Oh, and also, it doesn't say anywhere in RCW that, okay, Mark, are you done? Just lay her down. Lay down. Also in, what was it, RCW 26.44.170, there's also a statute that they should follow, but they don't. And RCW 1334.1103A says that I need to sign. My signature and consent is required to be on any dependency order, and they don't have it on any dependency order. And the reason why I refuse now is because obviously accepting and doing what they say didn't work since 2009, so I don't think doing what they say will work now. And it didn't work now because even now when I said I did, like, it's like, I don't understand why they're surprised that I don't comply. Like, you commit forgery, and then forgery, then you don't have probable cause, then you don't ever give me visits, then you constantly let them take vacations when they're not supposed to take vacations because they're only allowed 2 weeks per 6 months, and they take like 6 weeks per 6 months. And then, so you're never giving me visits, you commit forgery, you commit perjury, and then you want me to comply with, what? It's like, why would I comply when you commit all these like federal felonies against me, and then you say I don't do anything anyway? So compliance is out of the question. Like, I don't have to comply with anything because you're mentally retarded, and you keep saying I don't comply anyway. So what's the point? I mean, I'm going in circles with these guys, you know, and I try to be nice. I try to be for so many years, you know, and me being nice is, you know, suing them is being nice. That's just being nice because, you know, I'm publicly complaining about their crimes against me, and thank God I can do that much because you know, that's all I can do because nobody listens to me. I complain to the ombudsman; they don't care. They forced me into Christian school for 2 years. I couldn't do anything about it. I didn't think I could do anything about it either because I didn't know my rights. But it's like, you know, and really that's a crime. But they did it for 2 years. Didn't matter. Nobody cared. You know, and it's like I still have to go through all this like corruption. It's like they do this just to like get a reaction out of me. But really, it just makes me just keep suing them and suing them and suing them and suing them. And pretty soon people are going to know they're child abusers. And they're not going to be able to use their degree anymore because they're not going to be able to use their name anymore. Their degree will be worthless. You know, all that education for nothing. But, yeah, I guess I went crazy in the first, from 2009 to 2015. I didn't read any of my court documents and everything because it was too traumatizing to read them. And it was too, like, reading them would make me go crazy. So I never read them. And I never thought about suing or, you know, I couldn't look at my documents for that long to, you know, because it made me go crazy. So, and they know that. That's why they like doing this, because they think it's funny. You know, and let's see what else. Yeah, and I fired all my attorneys because they're worthless too. The attorneys work for them. The attorneys sign for them. And after I read the discovery and read that my attorney was signing for them, and telling them to continue on all these court hearings. I'm not the reason we're still here. My attorney's the reason we're still here. David LaRosse is the reason we're still here. They're child abusers. They enjoy torturing Amaya to get Title IV funding. You know, they like that bonus money, you know, and they get a bonus after when they adopt off Amaya to somebody else. They get what is it called? Adoption incentive bonus. They get to all apply for it. And my attorney actually helps the people who adopt them. So, you know, he's not just my attorney, he's the attorney for the adoption too. So, you know, they play both sides. You know, they don't care about kids, they just want to adopt them off. So that's the whole point of the Adoption Safe Families Act. That's the money she's getting. ASF, I mean, they call it the adoption, they don't call it the reunification.
Yes, I have an objection as to hearsay for the department getting bonus money for adoptions.
Okay, Ms. Zayas, what is the source of that information?
It's the Adoption and Safe Families Act. You can read it in the law. Okay. It's the law. Adoption incentive bonus. It's the law.
And is that one of the exhibits that you presented? You presented several that have law in them.
Really? I don't remember which one I did, but yeah, it is. They know it's the law.
Okay.
I have your Title IV applications. I can submit those as evidence. Okay. I mean, you can't get Title IV unless I'm on welfare. Okay. You can't get Title IV unless I'm single.
So without further foundation, the court will sustain the objection to hearsay, but the court will receive...
It's the law. It doesn't need to be... I mean, the law is the law. It's in the Adoption Safe Families Act. It's the law.
And is that an RCW or is that a federal?
No, public U.S. law. Public U.S. Adoption and Safe Families Act. You read the whole thing, you'll see that they get times this, times that, and only if they get more adoptions 1 year from the year before. If they don't get more adoptions 1 year than the year before, they don't get funding the next year.
Okay. So the court will...
It's in the law. You don't know how to read the law?
Well, the court will receive... will consider any exhibits that you want to submit with respect to that. So
it's U.S. law, Adoption and Safe Families Act. You know what an act is like the law, or do you guys know that law? Like right now, RCW 13.34 is the Juvenile Court Act. Mm-hmm. This is the Adoption and Safe Families Act. They're all acts, and they're all active law. Like now. I didn't think I had to submit the law. It's kind of like the Constitution. Like, it's a no-brainer. It's supposed to be already being followed by you guys.
Well, if you would tell the court the RCW or the USC that you're relying on, the court will consider. So, and you don't have to do that right now. But
no, I do.
Okay.
No, I do, because you guys are corrupt. And this is what you do it for. You do it for adoption, the adoption incentive bonus. That's what you do it for. So I have to. This is what my child was sold for, is the adoption incentive bonus. They are pro-adoption, anti-reunification. There's no reunification RCW. There's only termination RCW, and it's for good reason. Okay, so under the current adoption incentive bonus structure, states earn $4,000 for each adoption of a foster child that is above the number of the foster children finalized by the state. So basically, from the year before, and $8,000.
And what's the RCW?
Hold on.
Sorry. That's what I have to have.
I love when you guys act like you don't know the law and you get the money for it. The judges are in charge of this money. You should know it. Hold on, Mama. This is Section 473A of the Social Security Act. Adoption Incentive Program. 473A of the Social Security Act. The Adoption Safe Families Act 1997 ASFA PL 105-89. The social worker gets a bonus too. They don't get it in cash. The social worker gets it in money that they can use inside of their agency to create other programs. But most of them give it to the foster care that they want to do. I don't know. But they don't get it if I get reunified with Amaya. They only get it if she's adopted by strangers, not by her family, but by strangers. Anyway, my daughter, my 14-year-old was actually she got the adoption incentive bonus, and her foster mom got $1,500 a month until her 21st birthday. That's part of the adoption assistance that they get. It's like high-end welfare. It doesn't count against their income. But they get $1,500 a month until that child's 21. So when she turned 21, her foster parents put her out. Hold Oh, let me get back to what I was saying.
Okay,
I'm
get
sorry,
back.
clarify my objection. I don't object to the court considering the actual law.
Okay. I will figure out where the so what I'm finding is that some portions of the Adoption and Safe Family Act have been adopted by the state of Washington. I'm going to need to do a little further research to see exactly which RCW, so I will do that.
And I should say, I'm having trouble hearing the court. It's coming across the street garden.
All right, I'm going to take my mask off. Ms. Tran, do you object if the court takes the mask off so that, okay, all right. I have found that the state of Washington has adopted portions of the Safe Families and Adoption and Safe Families Act, so I'm going to do some further research to see which portions there are. So, and thank you for withdrawing your objection on the record. Do you have any objection to the court following that procedure, Mr. LaRosse?
No.
Okay, thank you. Ms. Cowan?
No objection.
All right, thank you. Go ahead, Ms. Zayas.